Yeah.
Good evening, sir.
Good evening, everybody. Good evening. Let
Sir, we can
everybody.
start now.
Yeah, we can
Some
start.
of the people have
Yes, yes.
joined. Yes, sir.
Uh, One of our friend, Mr. Ola, wanted to join you. Please help him out.
Yes, sir.
Ola.
I am trying to help him. I'm asking him his screenshot so that when he provides me, I can see what resolution can be brought in to
Yes,
let him.
yes. So on the last two lectures, we broadly summarized the provision relating to CRPC, that is the Bharatya Nyaya Sahitya IPC, as well as CRPC, that is Bharatya Nagrik Suraksha Sahitya 2023, comparing them with the provisions of the old CRPC and Indian Penal Code. I think some of the provisions which have been missing, because initially I gave you, we started the provisions of the CRPC Bharatya Nagrik Suraksha Sahitya 2023 from the stage of how the definitions have been brought about newly in the matter, and introduction of community service under section 23 for minor offences. Then a deletion, how the parliament legislature has this time deleted the expression uh, the metropolitan magistrate, metropolitan area, metropolitan magistrate, metropolitan area, and assistant session judges. These expressions, nomenclatures have been removed. Please note that here. Now we have judicial magistrate first class, judicial magistrate second class, like in other cities, in the city, uh, in the district or taluka places here. Then, after giving the hierarchy of the courts, then I also mentioned to you that the under the provisions of the new act, the modification, the power of the magistrate to impose fine from 10,000 to 50,000 has been increased. That is the judicial magistrate first class. Second class powers have been increased from 5,000 to 10,000. These are the notable changes. And community service, which is, please note that it is a new provision which has been added in section 23 of the new act. Community service means the work which the court may order a convict to perform as to form punishment that benefits the community, which shall not be entitled to remuneration. So once he is convicted for 1 year or 2 years, maximum 3 years, maybe say that. So the court may say that instead of putting them in jail, because the jails are overcrowded, and they may be allowed to do community services. So that will eradicate the burden of the jail service. Then we, these all provisions you learned. Then we started with the major changes which are made in the in the uh, filing of the first information report. The concept of zero FIR was introduced for the first time, which is being implemented, which will be implemented hopefully from 1st July, because fortunately the same government is formed the government, and there should be no difficulty in implementing the present laws. Okay. Uh, so the police officers all throughout India, with effect from 1st of July 2024, they will be required to register zero FIR. When the crime may have taken place in Bihar, maybe in UP or Delhi, if you're in Mumbai, come by Friday immediately. Somebody informs you that your house has been ransacked. You can go to the place. You are in Kolaba, you are in Bombay Central area, you may be in Bombay Andheri area. You can go to the place and lodge FIR. That is a zero FIR. It is the duty of the officer in charge of the police station where you lodge the first information report, that is the zero FIR. Of course, they are not explained the expression zero FIR, mean irrespective of the jurisdiction. Under section 154 earlier, that was the provision, the new section in the present CRPC relating to FIR, that is all of you know that is section 173 now. 173, it says every information relating to the commission of the cognizable offense, irrespective of the area where the offense is committed, may be given orally or electronic means. So you have a right to, earlier you can only lodge a complaint either orally or in writing. Now electronic means a WhatsApp pe bhi dijiye aap. You can send it through the email of the police station. Then within 3 days, the police officer will call you to come and sign it. You must record it. That's what you have to remember now. So you have a right to lodge a FIR irrespective of any place. There is no bar as such all throughout India, because under the Constitution of India you have a freedom of movement to travel anywhere, isn't it? That's your fundamental right under Article 19 of the Constitution of India. So similarly, you have a right to lodge FIR anyway, any part of India, isn't it? There is no bar here. So another significant change which has been brought about in the 173 of the new BNSS is in respect of offences punishable between 3 years and 5 years, the officer in charge is required to take the permission, with the permission of the superintendent of the police, he is the senior officer, and hold inquiry. This was not there earlier. Now this is made now compulsory. Now, in the light of the judgment of the Honorable Supreme Court in the Constitution bench judgment Dalita Kumaris versus State of UP, and Arnesh Kumar's judgment, where the Supreme Court emphasized that here, hold inquiry. You cannot, in matters in respect of matrimonial crime, offences relating to family, and petty offences, offences which are punishable for less than 3 years or maybe 7 years, you cannot arrest people without giving a notice under Section 41A. That was the concept. Now here they have specified in respect of what offences the officer will make inquiry. That is, offences punishable between 3 years and 7 years. Because they may be cognizable, may not be cognizable. When the police officer has the right to arrest or not arrest. This is for the purpose of arriving a prima facie finding whether he should investigate the crime or not. He has been given full discretion to decide with the help of his superintendent of police, deputy DSP, DSP with his permission, and decided that he cannot automatically arrest anybody, and he cannot automatically lodge FIR in offences where punishable 3 years and 7 years, and he must seek the permission of the DSP in the matter, with a view to ascertain whether prima facie offence allegations are made correct or not. Whether if the offence is a non-cognizable, he need not investigate, isn't it? He cannot even arrest people here. That he can do only with the permission of the magistrate. That you know that earlier Section 154, 150, 154, 155 in the matter here. Now, the another significant change in the match which is made is here that here the transmission, of course, the provision relating to women's offences also earlier there. Then I won't again repeat it here. Repeat it here to you. Sorry. Significant changes, electronic changes, electronic transmission, electronic message, where the police officer is under obligation to record it within 3 days time. And another important aspect is that he must give information to the victim about the progress of the investigation, and also the copy of the FIR. Formerly, you are supposed to give the copy of the FIR only to the informer. Informer can be a victim, cannot be a victim. Under the provisions of CRPC, the doctrine of locus standi is very wide. A victim may lodge a complaint, or his friend or a family member can lodge a complaint. You know that here. It is not like a civil case. Only the plaintiff must file a suit. Only the agreed person must file a suit. Without the power of attorney, having knowledge personally, you cannot. You can file a civil case. Of course, in even a civil case also under Order 1, Rule 8 CPC, in a representative capacity, you can sue for yourself on behalf of others if they are consenting, if they are known to you by joining them. That's the part. That is one provision which permits you to sue for everybody. But the CRPC, there is no bar except in defamation cases and personal grievance matter. Serious matters like murder, rape, robbery, any cognizable offense is punishable, you can lodge an FIR. A girl who has been ravished or raped, she will feel shy to go and lodge a complaint to the police station. You being the next friend, you being the neighbor, you being the mother, aunt, you can go and lodge a complaint. So the law mandates now the police officer is required to give them a copy in that regard. So please note that here the inquiry which I told you that here the time limit is now prescribed. That should be conducted within a period of 14 days. पहले अभी टाइम लिमिट नहीं था, अभी टाइम लिमिट डाल दिया गया. पहले इंक्वायरी का प्रोविजन, there was no provision at all. Now these mandates here, filing of the completing the inquiry within a period of 14 days, so that it is not unduly delayed here. Then the provision relating to furnishing the copy of the FIR to the victim is also provided in the matter. An investigation must be completed within a period of 90 days, which you learned it here. The police officer cannot delay the matter here. That is a significant change in the matter. Then another important change which is brought is under section 176, procedure for investigation. When a serious offense is committed, suppose a bomb blast has taken place, or food poisoning से death हो चुका है, then police officer is not an expert. He is supposed to take the forensic evidence and a videography of the process on his mobile phone. वो लेना पड़ेगा उनको. It is now made mandatory that that provision the government of each state has to make it, because the CRPC being a subject which both the central government and state government can legislate in the concurrent list here, the each state government has been requested and told, please make rules in that regard and provide forensic expert to visit the crime scene to collect evidence along with the police officer, and who will do the videography of the process on his mobile phone. So there's a concrete evidence. So there is an emphasis is on a videography, is on electronic evidence. So that because the earlier the electronic evidence, the concept was laid down under the provisions of section 65A and B of the Evidence Act in little condensed now, because there was a very strict procedure under section 65B. You have to obtain the certificate, ELIA, OLIA, under the Information Technology Act officers के लिए little cumbersome procedure which was laid down by the Supreme Court in Arjun Pandit Rao's case and Kotkar's case. That you know that it's a three-bench judgment of led by Justice Nariman's case, a very leading judgment. Now little requirements are condensed. Now if the police officer takes the videography with his own mobile phone, it is now considered as a primary evidence under section 62 of the Evidence Act. So he need not obtain certificate. Only if a message is transmitted to him by XYZ from London, America, crime वहाँ पे हुआ है, उधर क्या नाम conspiracy हुई है, some bomb blast is likely to take place in Mumbai, Calcutta, Madras. This is what I heard. Such messages authentication के लिए you have to invoke the provisions of section 65B and obtain the signature, obtain the opinion of the expert, under the Information Technology Act, which will be a secondary evidence, which will be falling within the meaning of section 65B. So section 65B is not dispensed with, but the primary evidence has been recognized. If you take the incident with your own phone, suppose for example a politician during the electioneering, he is distributing notes to his people in the locality. You capture it on your mobile phone. You may be belonging to the opposite party. So your mobile phone is produced before the court of law. It's a primary evidence before the court. But if you say that, yeah, my friend has transmitted me this message, I got the video message, videography, many of them are bogus. Many of them planted. They are morph messages. So the courts like to be very, very particular in that regard. Will tell you that certificate should be obtained under section 65B for establishing, for proving it as a secondary evidence that is not dispensed with. So here, primary evidence, the electronic evidence is given the status of primary evidence, which is very, very important in the matter. Then another recording of the confession, which was earlier section 164, now under section 163 of the 183 of the BNSS, video, audio recording means has been introduced. Confession. Now, earlier confession could be recorded only before the judicial magistrate. Now, confession can be recorded before any magistrate, even a district magistrate. Because wide powers are given to various magistrates now. The collector can record it now. It says any magistrate of the district in which a divisional magistrate can record it. The DM can record it now. So there is no bar. Of course, so long as he is not a police officer, who is conducting investigation, because he cannot be a person conducting the investigation cannot become a witness. You know that, no? Like you, like a doctor cannot perform operation on his own body. Like similarly, a lawyer also advise you should not be conducting his own case. Better to delegate to others, because you are bound to get personal. So similarly, a police officer bound to become overzealous. So the person is investigating the crime and he is told to depose and record confession. That will eradicate the effect of section 24 and 25 of the Indian Evidence Act, which clearly say that evidence, confession statement given to a police officer are not admissible. Inducement भी होगा उसके अंदर, promise भी होगा उसके अंदर, threat भी होगा उसके अंदर. Police officer will say that I will intimidate you if you don't cooperate with me and record the confession in the manner I say that I will finish your family. I will see to it that you are landed up in jail for a long time and lifelong. ये सब चीजें होते हैं. इसीलिए the police officer is not authorized. The investigation officer is not authorized to record the confession in the matter. Please note that any magistrate of the district under section 183 mean you can take a district. Mean it may be collector Mumbai. Collector Mumbai is a magistrate. Collector Mumbai is not conducting the investigation. He is a superior officer, IAS officer. Yes, he can be delegated the power. Sometimes, according to me, the correct word is it should be judicial magistrates. I do not know why the present act is giving power to various magistrates. I'm afraid, I do not. Maybe they think that the judicial magistrates are not available. They want to make availability to everybody. So please note that even a DM can record confession. A divisional magistrate can record it. Civil officers are sometimes they are delegated with powers of a magistrate. Of course, a police officer like ACP, DCP, who are also commissioners under the scheme of the present CRPC, they under the BNSS, they will not be permitted to record evidence, the confession in the matter which is made clear. Please note that here. Now, then we also dealt with these are the investigation provisions in the BNSS. Then investigation ke baad, we also explained to you the drastic powers after the completion of the investigation. If investigation cannot be completed within a period of 57 with 24 hours within the meaning of section 57 earlier. Now then what is the present status? What is the present status under present act? Section 58 it is when you open 57. Now it is 58. Now 58. Now 58 May investigation must be completed within. Then earlier section 167 that is relating to remand. There are some changes here, some disturbing changes. 167 earlier remand application where the magistrate can pass order confining the judicial custody of the accused to police officer not exceeding a period of 15 days. Now section 187 is the present section. When you see under the present 187, there are some there are drastic changes are made. Now section 187 subclause 2 ke andar the power is given for the magistrate to give custody for 15 days in a whole or in a part, initially for 40 days or 60 days out of the 60 and 90 days. 60 days, 90 days, that means police will have more opportunity to harass the Of course, harassment may be reduced provided there is a live facility of online and everything being recorded as such. But many police stations do not have Wi-Fi system. The government has to equip them very well. The investigation must be completed, must be taken place only with the help of the video recording, cell phone ke upar. If that is implemented thoroughly, then no problem. But granting custody for 40 days and 60 days, 40 days in offenses which are where the person is required to be custody for more than for about 60 days, he can be there for 40 days. In 90 days cases, custody can be given for 60 days. Mean the offenses which are punishable up to 7 years, he can be given police custody for 40 days. Where there is a life imprisonment above murder trial, and his custody can be given for 60 days, which is unreasonable, which is totally in contradiction to the earlier section 167 bound. That is one of the significant changes. Of course, they have brought out everything should be done audio recording means electronic means. No, that is only that these are the changes which are drastic changes under the provisions of 167, now section 187, isn't it? That you should know it. Then another, of course, we discussed the bail provision. उससे पहले मैं बताता हूँ देना. Then suppose what happens if a police officer does not register a FIR? He doesn't register FIR. You have a remedy. You go under section 190 CRPC. 190 CRPC is now equal to section 210. Now the changes brought about, I'll just discuss with you on 210. Please open section 210. Yeah. Yes. Leave it to me. Yeah. Yes. Under the scheme of, suppose the magistrate is the police officer is not taking cognizance, and you have a right to file, go to the magistrate in a private complaint, or the magistrate has a right to take cognizance of offenses under earlier section 190. Now it is section 210. Please note that the old section is 190. Now it is 219, under which the magistrate can take cognizance, number one, upon receiving the complaint of the fact, including complaint filed by a person authorized under the special law constituted the offense. Number two, upon a police report, that is 173. Earlier, that is a charge sheet. Now it is after the completion of the offense, 173 is now changed to the 173 earlier section, that is a charge sheet, is now changed to, give me the powers, relevant section, 173 of the CRPC. When you see the 173 old CRPC, इतना लंबा नहीं चलेगा. Yeah, those who have brought the CRPC can also help me in that regard. 193. 193. Be quick in informing. Section 193 के हिसाब से, that is presently the charge sheet can be filed by the police officer after completion of the investigation. Now there is a period of 90 days has been prescribed. The police officer shall, within 90 days from the progress of the investigation, he must file the charge sheet, including electronic communication, and to inform the informer and victim. See that here this provision was not there earlier. That is section under the provisions of section 173, that is relating to charge sheet, that is a police report. 193 subclause 3 के अंदर आप चेक करेंगे आप, subclause 3 के अंदर and Roman 2 के अंदर 90 days have been prescribed, and the information must be supplied to the informant as well as or victim, whoever is person. Now even under the provisions of investigation, the investigation relating to offenses, that is the offenses against the women, 64, 65, 66, 67, that is concerning rape and outraging the modesty, they should be completed within 2 months. That is under subsection 193 subclause 2 के हिसाब से. Then subclause 9 के अंदर further evidence which is sought to be collected. The further evidence provision under the old act was 173 subclause 8. Now it is now the provisions of section 193 subclause 9 हो चुका है. Further evidence, oral evidence, the investigation should be completed within a period of 90 days. See that here? That is subsection 9 of section 193. The police officer must complete in 90 days. A further time is required. He has to seek the permission from the learned magistrate, who passes an order under section 157.3, now which is now the provisions of the magistrate's provisions are now for investigation. 176. Please remember this section is very important. Earlier section, yes, procedure for investigation 170, earlier for 156.3 has now become, with the magistrate's permission, 176. Yeah, information.
156 of CRPC.
Yeah, 156.3. Check 156.3. 175. Yeah, it is now become 175. Power of the police officer to investigate cognizable cases. That is 175 subclause 3 now. Any magistrate. Now, what is surprisingly they have added here, the learned magistrate, while passing an order under section 175 subclause 3 in respect of a complaint against a public servant, he cannot pass the order of investigation without first giving an opportunity to the public servant, who will have a representation before a superior officer. This is a little surprising. This gentleman is the public servant is being insulated. That is very, very surprising. This was not there earlier. So magistrate doesn't have a power to immediately pass an order of investigation against a public servant. Now that is 175 subclause 3. So the incident should be reported to the superior police officer, and the public servant is told to narrate the incident. Thereafter, it is the wish of the public, the investigation officer to submit the report. Then third condition is the magistrate can order investigation. But in respect of the offenses which the police officer directly investigates, there is no such impediment. Police officer, maybe they think that the police officer will not take cognizance or arrest the public servant. When you see the provisions of section 176 में procedure for investigation, ऐसा कोई embargo नहीं है. 175 places an embargo. The learned magistrate under subsection 3 and 4, he cannot investigate, he cannot order the police officer investigate and arrest the public servant. The public servant, what he will do? He will take the permission of the DCP. Before the DCP, the public servant is given an opportunity to narrate the incident, given an opportunity. Please explain why action should not be taken against you. Thereafter only the action can be taken. This was not there. Now, whereas under section 176 now, police officer can directly investigate the crime against everybody, including the public servant. They know that the police officer is definitely mortally afraid of investigating politicians. इसीलिए वो blank रखे हैं. Police officer can investigate. So uske liye there is no reservation. But whereas a magistrate passing an order for investigation, there is definitely some embargoes. There are some stages which you have to cross that is unexplainable. Let the Supreme Court answer this when the petition is pending for discussion in this regard. So that is the contradiction point that has to be seen in the matter. Now, another important aspect of the matter is that here now, as I told you, that if the police officer does not take cognizance of your FIR, so he doesn't register a case. So your case is not registered under the provisions of section 210. Then it doesn't mean that you do not have a right to file a private complaint. Now the private complaint, earlier section 200 tha. Now earlier section 200, yeah, see 200 ka pehla section now be old section 200. Now the new
223.
Now 223, if you see section 223 of the BNSS, it is now examination of the complaint. This is a private complaint. So the police officer has not taken cognizance of a first information report in the earlier section 154. Now under the present section 173. Then following the Supreme Court judgment in the case of Priyanka Chopra versus State of UP, all of you know that if investigation is required to the police, number one, you have to first go to the police officer under the provisions of section 173, and if he does not take cognizance under 173 subclause 4, then you have to write a complaint, write a letter to the senior officer, that is superintendent of police, placing on record that my first information report has not been registered. Please, therefore, direct your police officer to register my complaint. No, that is Priyanka Chopra says that here you exercise the alternate remedy going to the deputy commissioner. अगर वो deputy commissioner भी आपका complaint नहीं लेगा, for reason best known, he may be a busy officer, या he may be knowing other side, he is lethargic or negligent, he doesn't have time. Then your recourse is to approach the honorable magistrate under the provisions of old section 200. Now the present section is section 200 का old section कौन सा है अभी? 223. That is a complaint to magistrate. So this complaint can only go, number one, you have number one FIR आपने फाइल किया under 173, action में नहीं लिया गया. Then you wrote a complaint to the superintendent of police under 173 subclause 4. That is subclause 4 में नहीं लिया गया. Then you will be normally filing an application under the old section 157(3). Now under the provisions of investigation, that is check करो. Yeah, 157(3) की जगह अभी that section for a investigation order by the magistrate is one 156(3) निकालो. Yeah, the new section I am giving you right now. In that regard, magistrate can pass 156(3), 175. So 175 में the magistrate passes order. अगर you do not want investigation by the police officer, then magistrate to take directly cognizance that provisions are now formally under section 200. now under the provisions of section 223 in chapter number 16 of the Bharatiya Nagrik Suraksha San. No, 23. Please note that chapter 26. The earlier chapter is now replaced now. Only they have replaced the chapters and replaced they have redrafted this section. So this will be little, the lawyers and judges will find it little difficult. But with the passage of time, you will overcome this. 223 now. Complaint to the magistrate के अंदर, sorry. Now, all of you know that the magistrate can take cognizance of the complaint under the provision of 200 without hearing the accused. All of you know that the procedure was under section 200. You file a police complaint. It is not like a civil case, notice to be given, reply, rejoinder, any. So under 200 of the old CRPC, you file a complaint to the magistrate, you will be examined immediately, or your witnesses. Accused is not, this is called pre-cognizant stage. At this stage, the accused is not called. Only the magistrate will only pay attention, take into consideration your evidence, your contents of the complaint, which should be supported by affidavit as per the judgment of the Supreme Court in the judgment I right now said, Priyanka Srivastava versus State of UP 2016 CRP 216 Supreme Court. That judgment take lijiye aap. You must make allegation and it should be supported by affidavit and provide the list of witnesses in the matter. The magistrate, if he is satisfied, he has to apply his judicial mind, examine you as a complainant and also your witnesses present under 200 old. Then if he is satisfied, he can issue process under 204. Or if he is not satisfied, he may say that I am directing investigation by the police under inquiry investigation 202 के अंदर by any magistrate or investigation by the police, वो भी कर सकते हैं. Now under the new provision or issue process under 204 directly, that was the old scheme. Now under the new act, that is 223, check करेंगे आप, complaint to the magistrate, they have brought a new proviso that no cognizance of an offense shall be taken by the magistrate without giving the accused an opportunity of being heard. This is unknown to criminal law anywhere in the world, neither in UK, USA, any part of the world. If you give notice to the accused person that the complainant has filed a case, come and give reply, the matter will be delayed. That means a magistrate is not being given chance, an opportunity to exercise his judicial mind. Either you're not trusting the judicial magistrate, or you think that the complainant is bogus, or you feel that here, like a civil matter, the defendant should be heard, file written statement, and without hearing him, no order should be passed, like is done in the matters under the administrative tribunals, which is being done here. So in a criminal matter, in a private complaint, the first time, this section has come and accused is being given the opportunity of being heard. That means magistrate cannot pass any order taking cognizance. He will not say that I am issuing process. He cannot even say that I am issuing investigation. He cannot even say I am directing inquiry. His hands are tied here. The first proviso completely debars that procedure, which is unusual. This will simply delay and detract the matter further. In my opinion, let us see what the Honorable Supreme Court, yes, when in such matters, when issue process under 200, when the other side goes to revision under 397 or 401 to Session Court or High Court, there the accused is heard. That the Supreme Court has said in many cases because the first time he is participating in session. But in the proceeding under Section 200, as on today under the 1973 Act, by no stretch of imagination or by necessary implication the accused can be heard before issuance of the process. But यहाँ पे डाल दिया गया, ये proviso clearly mandates shall be no cognizance of the offence shall be taken by the magistrate without giving the accused an opportunity of being heard. So according to me, this will definitely prolong the proceeding. You may be wanting to satisfy the principles of natural justice or the principles of audi alteram partem in criminal cases also, like administrative tribunal cases and also civil cases. That is remains to be seen what is happening. Okay. Then iske baad, this is the procedure. Then when you know that after the investigations are completed, then the chapter relating to charges, what changes are brought, I'll bring to your attention. That is earlier section in the CRPC was 211. You must be aware of it. Chapter 211 to 224. The original chapter was 27. Now there's a new chapter called 28 on chapter charges, commencing from the charges, section 234. The old, this is the old CRPC was in chapter 17, covering section 211 to 224, old. Now the present BNSS covers chapter 14, chapters 18, covering section 234 to 247. Now we'll just glance through what are the changes in the charges here. Now section 219 ke andar, that is a clubbing of the charges I'm talking of. There are no maximum, there are minimal changes here. What are the significant changes? The section 219, open the old act. Under the old act, section 219, that is a joinder of charges. You may be knowing the offences which are committed within a year may be charged. That is up to 3 offences. Now under the new act, 3 offences can be clubbed together. Maybe cheating, misappropriation, or koi bhi charge 30. The 3 charges, 3 offences can be clubbed together and tried under 219, old CRPC. Now under the present act, section 242, you can club up to, join up to 5 offences. See that section is a new section is 242. Yes. 242 offences of the same kind within a year may be charged together, not exceeding 5 now. पहले 3 थे, अभी 5 हो गए. Remember it here. Then other sections 211, 212 to लेकर 24 are same. That is the BNSS 234 से लेकर 247 or more or less same. There are no changes made here. Please note that here. Then I will come to you the procedure for a trial before in the CRPC. So all of you know that a trial before a court of sessions, then that is commencing from section 225 onwards, 225 to 237. Then trial before the magistrate in warrant cases, trial before the magistrate in then trial before the give me that CRPC, trial before the magistrate 225 से शुरू होता है trial है, that is a sessions court. Yeah, that is a 225 to 237 in chapter number 18, session trial before a court of session. Now I will first take you through what are the changes in it. Give me that. Give me the changes which have been brought where we made the note. Now if you kindly see the provisions relating to trial before a court of sessions now are mentioned in chapter 19, commencing from section 248 to 260. Now the changes which are brought here, that here Now, under the provisions of section 250, where discharge can be done, the discharge provision earlier was section 227. There was no time limit. The moment the matter is committed to the Court of Sessions from the magistrate under section 209 CRPC, anytime the accused can make an application under 2227 before the learned session judge for discharge on the ground that there is no material to frame charges. There was no time limit prescribed. Now the corresponding section in the present BNS Act is section 250, under which 60 days time is given for making application for discharge from the date of committal. Committal was under 209 earlier, now it is 232. The present section, committal means all of you know that in all cases, either triable before a court of session or a high court, the learned magistrate is the court of original jurisdiction in criminal matters, CRPC ke andar, and the accused is brought before him immediately, and the magistrate is the one who considers the application with regard to investigation. Police custody dena hai, judicial custody dena hai, that is a procedure relating to remand. Then once the procedure is completed, if statutory bail is required to be given, magistrate has power to grant bail even in serious cases. And when investigation is completed under the provisions of 173 Old Act, now under the present section, after completion, charge sheet is submitted to the magistrate only. Even if the murder case ke andar, rape ke trial may be, even if the offence is triable by the court of session, the police officer submits the charge sheet before the magistrate only. Then the next procedure is that here the learned magistrate is required to provide the application to the accused person under 204 and 207 the copies of the charge sheet and all document. 204 relates to document being provided in the cases triable by the magistrate, and 207 is the procedure related to for providing a charge sheet to the accused person in respect of offences triable by the court of session. Then वो होने के बाद committal होता है. Committal is section, our old section is section 209. Now the new section is 232. 232. 232 speaks of committal proceeding. So the magistrate, the learned magistrate performs more or less the duties like a post office, from collecting all the material, and he transmits it to the superior court, the court of session or the high court or the special court, wherever the trial is required to take place. So that is the committal proceeding. Now the law says that here, once the committal proceeding take place, the court of session takes cognizance of the matter, is in charge. The court of sessions as a special court or in the court trying all matters which are triable by virtue of the powers under the CRPC, it has power to issue summons, it has power to issue warrant, and it will take over from the magistrate. Then the magistrate has no role to play thereafter. Then the accused person gets an important right to make an application for discharge before the learned session judge under the provisions of section 250 BNSS, which was earlier 227 on the old act. Now under the old act, there was no provision which said that here time limit kuch bhi karte the, because now the law said that now within 60 days you must make the application for discharge. That is one note change you have to make it now. Okay, I won't be reading the section, that will consume our time. Then thereafter, the learned magistrate must frame the charges under section 228 session judge ke liye. Now on the new section is 251 of the BNSS, framing of charges. That should be done now within 60 days. Pehle provision mein there was no statutory time limit. Under the old section 228, there was no time limit because the learned session judge frames charges when there's a material and record. Of course, the accused person gets an opportunity to go to the High Court to challenge it. The learned magistrate, the session judge should not have framed charges. There was no material and record that you get right under 401 or 227 or 488, 482 के अंदर वो अलग बात है. But when it is not done, he has done his duty. He said that the statute mandates now within 60 days period, the charges must be framed pursuant to section 251 now. Please note that here. Now, उसके बाद the next procedure is evidence of the witnesses. Evidence of the witnesses, that is earlier section 231, evidence for the prosecution 231, then evidence for the prosecution now is section 254 under the BNSS Act. Now the public prosecutor, you know that he begins the case. Then here the new section is added new year, provided the evidence of the witness, the subsection may be recorded by audio, video, electronic means. यहाँ पे this was not there earlier. Then subsection 2 says the deposition of the evidence of any public servant may be taken through audio, video, electronic means. ये भी new है. Please note that these are new sections added in section 254 of the BNSS, which were not there under earlier CRPC under section 231. Okay. Then under section 235 CRPC earlier, judgment of the court of acquittal or conviction. That is the power of the court after conducting a trial. There was no time limit period. There was no time limit period under section 35 CRPC. Now the new section, corresponding section 258 of the BNSS mandate that after hearing of the argument and the point of law, if any, that the court shall give judgment as soon as possible within a period of 30 days. 30 दिन का time limit क्या है? From the date of the completion of the argument, which may be extended to for 45 days. 45 days में, is it possible for a session judge to record the judgment? Of course, there are no consequences. It is a mandate. Of course, you all know that CPC and CRPC are procedural laws. Procedural laws are required to be construed in a liberal manner for advancing the cause of justice or not to impede justice. If procedural laws are not complied with, magistrate or judges cannot be punished. Even parties cannot be punished. The courts have power. The courts have inherent power to, of course, according to me, the present court should have also given the inherent powers to magistrate and session court. Under the Code of Civil Procedure, section 151 says that inherent power can be exercised by all civil courts. Then why the magistrates, the session judges and magistrates are being deprived? I fail to understand. The legislature had the opportunity, they missed the opportunity. They should have given this power. For every little small order, you cannot rush to High Court under 482. 482 is the inherent power of the High Court under the CRPC. Why only High Court is given? Why the High Court should be flooded with matters? Why you should have given the powers to the learned magistrate? Should have given the power to the learned session judges. So I fail to see that this is a failure on the part of the legislature. They should think over it, redraft the again CRPC, the BNSS, and make this provision. So it is not possible like this. So in my submission, this is a lacuna. With great respect, they have missed the opportunity which they can avail it. Still, there is time before implementation, enforcement of the act coming into operation 1st of July. Abhi bhi think over kar sakte. One of you who are hearing the lectures can pass on the message if it is possible. Then there is a BNSS के अंदर देखिए, order of compensation earlier earlier that you know section 258 BNS. Now old section 235 CRPC निकालो. Old 35 CRPC. Section 235 CRPC relating to what is the amount of for making false accusation. 235 के अंदर there was no amount prescribed if the accusation is for judgment on acquittal or conviction. The accused is convicted, the judge shall unless proceeds upon it. Now here there's a new section is added, maybe 258 subclause 2. The court shall order the consider the course which may shown the person so directed, satisfied that there was no reasonable cause for making accusation. It may, for reason to be recorded, make the order that compensation to such amount not exceeding 5,000 rupees. So the accusation are found to be incorrect, not tenable. Now the judge has been given power to award compensation. Now, under the old act, I do not know procedure in case incident. Yeah, that is okay. That is the compensation part. Now 5,000 कर दिया गया है. पहले तो 10,000 quantum of compensation under 237(4) CRPC is increased to 5,000 now, because the magistrate earlier 10,000 का power था, अभी 50,000 is the compensation which they can award. That is taken. Now come to trial of second trial is the important trial. Trial of warrant cases before the learned magistrate. Now that is a trial of warrant cases. Chapter 20, chapter 19, chapter 19 in the old CRPC, section 238 to 250. All of you know that. Now this has been now replaced, substituted into new chapter 20. एक chapter add हो गया, chapter 20 कर दिए. Our sections now 261 to 273. Now what are the notable changes? I will draw your attention. A trial of warrant cases by the magistrate. I mean, what is a warrant case? A case which is punishable for more than 2 years is a warrant case. The definition section 2 के अंदर है. हमको मालूम है इसके. Warrant case and trial summons case. Yeah. Now here 262 के अंदर. Now 239 CRPC dealt with discharge, old CRPC. Now the new section is 262 when the accused shall be discharged. Now discharge application again should be mailed 60 days time. Now like the earlier session trial के अंदर, even before a magistrate where you have power to make discharge under section 239 in warrant triable cases. Sorry. Now the new section for discharge is 262 and which should be made within 60 days from the date of the copies of the document under section 230. Now the section 230 of the present new section when you open section 230, supply to accused copy of the public report and other proceeding. This was like earlier section 204 and 207. Okay. Now 230 के अंदर. Once the copies are now furnished, give me. Yes. Yes. 60 days time from the date of the furnishing of the copies. Under section 230. This is a new section. This was not there earlier. Now subsection 2 says, upon considering the police report and the documents under 193 and making the examination, either personally or through video recording case. So यहाँ पे audio video recording means the magistrate can pass the order of discharge in the matter, of course after giving the prosecution an opportunity of being heard. So these were all there earlier. Now they have added either physically or through audio video electronic means. That has been now added in the new section with regard to trial before the magistrate in warrant cases. Now there is also section old 240 framing of the in a trial before the Yeah, in a trial of warrant cases before the magistrate, 240 provided for framing of charges by the magistrate, because magistrate has to frame the charges like a session judge. Now, 263 of the BNSS is the corresponding section under which charges are framed by the learned magistrate in a warrant trial conducted by him. Now, the new changes which are brought are he should frame the charges within 60 days from the date of the first hearing of the charge. So, general charges are framed under the provisions of section 211 old CRPC. Now, the special charges are framed by both the session judge as well as the magistrate in their each section. So, within 60 days, time limit is given now. Now, then time-bound framing of charges, 60 days. Yes, 60 days. This was not there in the earlier CRPC. Now, time-bound framing of charges, that is 60 days from the date of the hearing of a charge. No such limit was there in section 240 CRPC. Please note that. Now, under the scheme of the old CRPC 242, evidence for prosecution, that is in a trial of warrant cases by magistrate, you remember it here, section 242 was for evidence for the prosecution. And now corresponding section is 265 of the BNSS, evidence for prosecution. There are some slight changes here which I will bring to your attention. It says that provided further, the examination of a witness under the subsection may be done by the audio, video, electronic means at the designated place to be notified by the state government. अगर आदमी जेल में रहेगा, jail custody में, so he cannot be compelled to bring to the court. Say वहां से jail custody he may be in Eroda jail, he may be in Pune jail, he may be in Thana jail. अगर मुंबई भी recording करना evidence, that is even if he is in USA jail, isn't it? In bomb blast cases, one of the accused evidence was recorded from USA. All of you know that session court के अंदर record है वो. So now it is fortunately this provision has come up in almost all proceeding. If it is implemented, it will become easy. The courts will not be too much crowded. Rivalry will not do, and the accused person will not become desperate, and shooting, getting will stop the court. Then there is also explanation added under the new proviso section 265. That is okay. Then under 243 evidence for defense, 243 old, now new section is 266 BNSS, evidence for defense. So evidence for prosecution, now evidence for defense. Now यहाँ पे भी defense का evidence also, examination of witness under the subsection may be done by audio, video, electronic means at the designated place. So it is given up. Both the persons are given opportunity to place it on record. The police officer need not bring them on record. They did not come to the court. Like both under the CRPC and under the CPC also, there are provision for recording evidence by commission. Court commission can be appointed, isn't it? Court come under the provisions of Order 26 Rule 1 CPC, commissioners are recording evidence. Similarly, under the provisions of CRPC 300 and no 299 खोलिए आप. Yeah, recording of evidence in the absence of the accused. एक मिनट, no affidavits के अंदर है. The commissioners no, yes, एक मिनट. Government certificate where evidence can be recorded by appointing commission. In the CRPC, you will find it old section, new section 286. Execution of commission starting from attendance of witnesses 284. When then attendance of witnesses may be dispensed with and commission is issued. 284 is old section, 284. Now the new section is 261, isn't it? 284 is the old section. 319 is the new section. Of 319, if you open it, 319, section 319, I will just draw your attention to the salient feature, when attendance of a witness may be dispensed with and commission be issued. Similarly, the provision under the provisions of Code of Civil Procedure Section 75 and Order 26 Rule 1, where you can make the application to the court, the commission be appointed for recording evidence. They are procedural laws. So here 319, commission may be 320 and execution 321 of the present CRPC, return of commission 323, elaborate provision. Okay, that small changes are made here, but electronically it can be done now. Electronic mode can be done. That is let us see, provided our Wi-Fi is everything work together. Many people complain, lawyers, we are not able to approach courts and argue cases in Supreme Court and High Court because we do not have facility. We don't have Wi-Fi in our villages. So that should be now provided. It is a duty of the government. Now the third trial which is contemplated under the CRPC, all of you know that, trial of summon cases in the old CRPC, it was chapter 20, running from section 251 to 259. Now the corresponding section in the BNSS is chapter 21 and running from section 274 to 282. 274 to 282. Now what are these changes which are brought in 274? That is summon cases may charges are normally not framed, only substance of the accusation is stated. You know, magistrate is not bound to frame charges. He is only substance of the accusation is explained to the accused. Now it says then एक proviso add किया गया इसके अंदर, provided if the magistrate consider the accusation as groundless, he shall, after recording the reasons in writing, release the accused, and release shall be effect of discharge. This is a new provision. It's a laudable provision. I like this. Earlier CRPC did not contain this provision. Now when you open CRPC का earlier section 251, section 251 check करेंगे आप. Section 251. Yeah. 251 did not have any proviso. So there was no provision for discharge. Now, like in session cases, on a trial of a warrant cases, where there is a provision for discharge, now even in trial of summons cases, there is a discharge. Now the famous case which went to Supreme Court, a defamation case which was sought to be challenged, there is a Malayalam Manorama's case. Justice K. M. Matthews' judgment, you must see that here. He commented upon why there is no provision in the CRPC for quashing a complaint for trial of the summon cases. Probably taken, maybe had taken the clue. That is a famous case of the Supreme Court in the early 80s. You may say that here. Malayalam Manorama's case. That is a editor of who was prosecuted for defaming the Chief Minister of the Kerala. That's a leading judgment. So in that light, probably here, it is a beautiful development in the CRPC present BNSS. What is good, we must appreciate and we must thank the legislature. So the provision for discharge is added now. You need not go to the High Court under 482 for quashing. You need not go to the Session Court under 397 by way of revision for quashing. You can make an application to the magistrate himself. My lord, there is your honor, there is no, that the charges are groundless here. The complaint is bereft of any material. So therefore, I may be discharged. It's a new provision. Please remember this, all of you. This will be useful. Then non-appearance or death of the complainant. That was section 256, earlier section. 256. When non-appearance ke liye, when the complaint is to be dismissed. Now the new section, non-appearance and death may, the time limit is given now. Earlier there was no time limit. Now it says if summons has been issued on the complainant, and on the day to which the hearing may be adjourned, the complainant does not appear, magistrate shall, after giving 30 days time to the complainant to be present, notwithstanding anything there in the force, acquit the accused unless the same. So this is akin to the old section 256, but there was no time limit. The magistrates in civil, the judicial magistrate, first class, second class, you must be knowing it. 10 years the cases are pending. Complainant is not coming. Accused makes an application, my lord may discharge it. He said, oh, kya balenge? No, you again, I'll reissue someone, or a warrant may be issued under the provisions of the section 85 CRPC 87. It happened in many cases where I also appeared in many cases. The judges, they are either busy, there is no time limit. No, fortunately, time limit is framed. This is like under the Code of Civil Procedure, under Order 9, if the plaintiff does not remain present, ex parte decree will be passed. The suit will be dismissed. Isn't it? Like a defendant does not remain under Order 9, Rule 13, the suit will be dismissed ex parte. So Order 9 provisions are lifted. Of course, CPC can there be also require some radical changes. Time limit should be prescribed. There is no time limit also given except in under Order 8, where written statement should be filed within 1 month or 60 days or 90 days. Some, but everywhere there is no such. Some changes are required. Otherwise, civil trials also drag like here. So this is a laudable this particular change under section 279 provides 30 days time given that the magistrate should dismiss the case if within 30 days the complainant doesn't come. So you cannot keep the matter prolonged like anything in the matter. Then last is the fourth trial, summary trial. So all of you know that summary trial proceedings under the CRPC, that is chapter 21, running from section 260 to section 265. Now the corresponding section in BNSS is chapter 22. One chapter is added extra. This is covering from section 283 se lekar 288. Now, what are the changes I will just bring to your attention under the new act here? That is under the earlier the magistrate, notwithstanding anything contained in the code, chief judicial magistrate, metropolitan magistrate. Now metropolitan magistrates are now wiped out. They have been demolished. Their offices are abolished. Sorry, they are abolished. Now we have only judicial magistrate, first class and second class will try the cases. Now normally summary trials will be conducted. These are petty offences in city of Bombay, everywhere. Judicial magistrate second class chalange. Isn't it? They cannot award punishment more than 3 months. They cannot try offences which are more than exceeding 2 years. All of you know that here. Now let us see the changes which are brought about, that under subsection 2 of the 303 and 305 in section 379, 380, 381. Bharatya Nyaya Sanitya, the value of the property stolen does not mention that exceed पहले amount 2000 rupees tha, isn't it? 2000. Now the amount is enhanced to 20,000 rupees. He can try offences up to where the value of the property is 20,000, because these are now mandatory to be. The summary trials now are mandatory. पहले mandatory नहीं था, it's a discretion of the magistrate. Yeah. The other changes, then receiving, retaining stolen property under subsection 231C in section 411 IPC, old man, receiver of the stolen property. The earlier was the 20,000 rupees. The earlier was the amount was 2,000 rupees. Receiver of the stolen property, where the magistrate can try summary trial. Now the amount is enhanced to 20,000 rupees. Okay. That you should know that the changes in the Roman surplus 2 ke andar. Then third is assisting in the concealment disposal of the property. Subsection 317 of the Bharatiya BNSS, which was earlier section 414 of the IPC. Isn't it? यहाँ पे concealment and disposal of the stolen property. चोरी करके छुपा दिए property. Isn't it? The value of the property earlier was again 2,000. Now it is enhanced to 20,000 rupees. Now these are the offences. These are petty offences up to Now 20,000, the magistrate can try in a manner that is a summary trial, which should be done expeditiously. Then the another changes which are brought is under subsection section 311 of the BNSS, which was earlier section was 454, 456, 450. That is earlier this was in the new law. That is open this section 454, 456. IPC खोलिए ना. If you open 311, that is record and trial before the court of session. Open it. 450. Yeah, lurking house trespass. That is a lurking house trespass. And 456 was a 456 punishment for lurking house trespass, where the offences have now been, it is in the new law, these sections are now 311 to 311. Yeah, subsection 2 and subsection 2 of 311. Then thirdly, insult with the intention to provoke breach of peace, which was earlier section was 351, which was earlier section 504 of the IPC, which was a petty offense, isn't it? Where the punishment for fine was 2 years' time. Now, under the new section 351, summary trial can be conducted, must be done earlier now. And new section 351, which was earlier 506, that is intimidation. Section 506, the new section is also can be tried now in a summary trial. Then abatement of any of the foregoing offences earlier, new section, they also can be tried in a summary manner. Attempt to commit any of the foregoing offences. Yeah. Then the magistrate may, after giving the accused a reasonable opportunity of being heard, for reasons to be recorded in writing in a summary way, all or any of the offences not punishable with death, imprisonment by life for a term exceeding 3 years now. Now, pehle 2 saal tha, now it is now 3 years offences. He can try in a summary trial. Please note that here. Provided that no appeal shall lie against the decision of the magistrate to try cases in summary under this section, is a newly added here. No appeals will not lie here. The old sections for your reference is in this regard. Yeah, this is a new section which is added. Please note that here. Imprisonment for a term exceeding 3 years, and no appeal is provided for summary trials passed by the magistrate. When appeal no mean, normally people will go in revision. 397 and 401, isn't it? What could not be done directly can always be done indirectly. Now, there was an earlier provision in the CRPC, you must have heard of plea bargain. Under the chapter number 21A, running from section 265A and 265L. Kya time ho gaya abhi? 70. 265L. Now there is some slight changes. Now the new chapter in the present BNSS is chapter number 23, covering section 289 to 300. So they have organized it now. No more ABCD. Okay. Now here the changes made are application for 265 earlier was plea bargain. That now 290 application for plea bargain. Who can make it? An accused person who want to do settlement, isn't it? That now this should be made within 30 days from the date of the framing of a charge. No, you know that here the offences which are punishable up to 7 years, you can go for plea bargain. All of you know that here. Now the time limit is prescribed 30 days. Then it should provide not 60 days to public prosecutor or a complainant to work out the mutually satisfactory time limit. 60 days time is given to the, excuse me. Earlier there was no time limit. No? Please note that. Now 30 days time is given to the accused from the date of the framing of a charge. Normally in a warrant trial में होता है ऐसा warrant trial. Yes, you can do that here. Even in I don't think there is no bar in going in offences which are punishable up to 7 years. You can go there. Then the public prosecutor must complete the formalities, taking the consent of his client, that is the complainant or a victim, within 60 days. Okay. Now the changes which are brought about are, normally you know that here the first time offenders were earlier given 1/4 of the minimum punishment. समझे ना? Agar punishment was a 1 year, at least the magistrate will say that you undergo punishment for minimum 3 months. That is 1/4. Now the present act has reduced it now. If the accused is a first time offender and has not been convicted of any offense in the past, it may sentence the accused who 1/6 of the punishment. So instead of 3 months, now you undergo only 2 months punishment, if it is punishable for 1 year. So 1/6 of the punishment provided executable as the case may be offense. These are the two notable changes in the act which you may kindly remember that in the plea bargain proceedings. Then some changes which are brought about in evidence and inquiries in trial. In CRPC you have evidence and inquiries and trial, isn't it? That the earlier chapter was a chapter 23 running from section 272 से लेकर 299. I mean, after completion of the filing of the charge sheet, framing of the charges, then the trial commences. The inquiry, how the documents to be produced and how the magistrate, how he conducts it. Now the changes which are brought about, I'll point out to you. Open it here. Yeah. Section 307 onwards. That is in evidence in inquiry trial. Now, section 308 now, earlier section 3 now said evidence to be taken in the presence of the accused, which was the earlier section 273, isn't it? That there are no much changes in that here. Now, what is the changes? I'll point out to you. The changes are 281 के अंदर है. Section 281 खोलिए. I'm not taking out to everything changes. That is record of examination of the accused. Now that is new section is 316 record in summon cases in inquiries. Now it says now whenever the accused is examined by a magistrate or by a court of session, the whole of the examination, including every question put to him, answer given by him, shall be recorded fully by presiding officer, by the judge himself. He is unable to do so owing to physical or any capacity under this section or reason. यहाँ पे proviso add किया है, where the accused is in custody and examined through electronic communication. His signature shall be taken within 72 hours of the examination. So new proviso has been added to section 316, which was not there in the earlier section. Send message, I'm at lecture. Let's go. ये करो ना. Why don't you put it in
I did that.
ये message पे डालो, ये mode पे डालो. Yeah, this proviso is a new proviso, that is a examination through electronic communication, and signature of the accused should be taken within 72 hours. Okay. This is a new section 316 subclause 4. Please note that here. One changes here. Now, you know that here old section 294 say no formal proof of certain documents. 294 you must be aware of here. 294 खोलिए. No formal proof of certain document. Evidence Act mandates that here proof is strict. Section 3 of the Evidence Act tells you what is evidence. Oral evidence, documentary evidence. But the Supreme Court's various judgments will tell you that evidence also mean corroborative evidence, presumptive evidence, circumstantial evidence, isn't it? Then positive evidence, direct evidence, primary, the best evidence. These are all rules. When you go through the Supreme Court judgments, you will come to know that. So one of the Supreme Court judgment, full bench judgment, had described this. You get the judgment of the Supreme Court. I'll just give you the citation where this evidence has been described. Judgment. Hardeep Singh versus State of Punjab. उसके अंदर Supreme Court ने laid down किया है. I will give you the relevant paragraph. What are the various types of evidence? Where is it mentioned? Evidence, various types of evidence. Give me the judgment of the Hardeep Singh case. Yeah, I will just point out to you the paragraph of the Supreme Court in Hardeep Singh's case. Please give me 1 minute. I will just take out from my mobile phone. Which paragraph? Just tell me.
Para number 59 के बाद.
Yes.
After 59 it is.
We have mentioned.
The circumstantial best positive.
I mentioned the paragraph. See, just see which paragraph. Where the Supreme Court said that it is not just oral evidence and secondary evidence and various evidence. The citation I'll give it to you all. Which paragraph number?
59.
Yeah, please see paragraph number. The citation is Hardeep Singh. Give me the judgment copy. Please get the judgment. Paragraph number 18. Yeah, I'll just give you. Please give me 1 minute. Yeah, the citation I would like. Citation of the judgment is, please take down, 2014, 3 SCC, page number 92. That is party's name, Hardeep Singh versus State of Punjab, is given by the Constitution Bench of the Chief Justice Satar Shivam, Dr. Chauhan, Dr. Justice Chandra Desai, Justice Gogai, Justice Bobde. And the relevant paragraph dealing with the describing various evidences. एक कहाँ पे बताइए? नहीं notes में लिखा है तुमने. Why is making it?
18 only we have written.
नहीं दिखाओ मेरे को show me. So in that the Supreme Court has described. You please go through that. What are the various types of other evidence? Presumptive evidence. There is a corroborative evidence. Corroborative evidence come under section 156 and 157 of the Evidence Act. Then contradictory evidence under section 145 of the Evidence Act. Then secondary evidence is section 65 of the Evidence Act. That is all to be taken. Then circumstantial evidence, when you read that the Supreme Court judgment, you have to see various Supreme Court judgments. Circumstantial evidence is the best. Parties may lie, witnesses may lie, the circumstances may not lie. That is how it is. Yes. Then the present section is 294 is 330 BNSS, where soon after the supply of the document, no case later than 30 days after such supply, provided that the court may on a discretion relax the time limit, reason to be recorded in writing. So this is how the evidence to be completed within 30 days. Evidence. It is so difficult. I don't think it can be done. isn't it? That the commission should be completed. Then no expert shall be called to appear before the court unless the report of the expert is disputed by any of the parties to the trial. So under the Evidence Act, you have entertaining experts, people who give their opinion. So normally expert evidence is admissible only provided there should be a report as well as the expert should be examined. So here the expert is dispensed with under the scheme of the new CRPC, because under the Evidence Act, there's a section, you will remember section 58, if I think, admitted facts need not be proved. If other side is accepting the report, forensic report, why do you call the forensic gentleman? If a doctor's report is not contradictory, if accepting, then why do you call the doctor? His time is saved here. So these are the changes which are made in the trial procedure under the CRPC. Yes. So these are the maximum changes which are in the CRPC in the trial. Yeah. Why do you say section 89? See, the Supreme Court in the case of Hardeep Singh versus State of Punjab, 20143 Supreme Court cases, page number 92, deals with defines the evidence at paragraph number 63, which is also defined earlier in Kalyan Kumar Gogai's case. It says the word evidence is used in common parlance in three different senses. Number one, equivalent to relevant, equivalent to proof, as equivalent to material, on the basis of which courts come to conclusion about the existence or non-existence of a disputed fact. The definition of the word evidence given in section 3 of the Evidence Act, one finds only oral and documentary evidence. This word is also used in phrases such as evidence, circumstantial evidence, corroborative evidence, derivative evidence, direct evidence, documentary evidence, hearsay evidence, then indirect and direct evidence, then original evidence, presumptive evidence, primary evidence. That is paragraph number 66 in of the full bench judgment of the Constitution bench judgment in Hardeep Singh's case. Please go to that. According to me, these are the various changes in the CRPC, which if you remember, you'll be happy with it. Anybody want to ask me any question, please do that before I take up other topic. And mind you that here, the new CRPC is introducing witness protection provision. Where is that? Witness protection. The new provision, section 336 खोलिए आप. 336 एक मिनट. 336 BNSS में this is the first time which has come. Oh, witness normally the court के अंदर आते हैं, evidence देते हैं, they are gunned down. Now it is the responsibility of the state government. The new section is 336. This is a very important section. Evidence, yeah, नहीं. What are you saying? गलत दे रहे मेरे को. नहीं. relating to witness protection, section 500 meta it is. Anybody able to recall it? Where are my notes? I put handwritten notes.
Yeah, this
one. 530 speaks of all trials to be held in electronic mode.
530 is new.
530 is name. There is also witness ka protection. Check karo. There is a separate protection. Witness protection. Anybody can give me the correct section of witness protection in the new CRPC? Kumar, can you lay your hand? Inquiry track, yeah. So what is again newly added is section 530, which said that here trial and proceeding to be held in electronic mode. Please note that this is a totally new. All trials, inquiries, and proceeding under the Sanithya, including issuance of service of execution of summons, warrant, examination of complainant witnesses, recording of evidence, including inquiry, trial, and all appellate proceeding and other proceedings may be held in electronic. It doesn't say shall, may be held. Whereas the police officer has been mandated to record FIR and other meetings holding investigation, it says it shall. So subject to this, according to me, the CRPC is now complete. Only I just want to lay my hand and tell you the exact provision for witness protection, which is there in the new CRPC. Why you're not able to give and give? I have worked out on it. I have written down, see somewhere. Now, before I turn to the Evidence Act, now I will take you through the new sections which were added in the Indian Penal Code. The Bharatiya Nyaya Sahitya, we mentioned last time till section 69. That is, they have abolished they have dropped the provisions of deleted section 261B omitted, 226, 238, 238 is deleted. काफी delete कर दिए and provision relating to adultery 497 deleted, breach of contract is deleted 492, unnatural offences, there is Josephine's case of the Supreme Court following 311, 377 is deleted, and section was unanimously struck down by the Supreme Court in the 5-bench judgment in the case of Joseph Shine.
398.
क्या चीज?
398 new CRPC.
बताओ मेरे खोल गए. Okay, then new section 22(3) has been added. Child definition of the RPC. 210 में transgender has now been given recognized under the new under the new Indian Penal Code definition. Formally it was not there. 4F में community service has been added. This is very important, significant. All trials which are triable by the magistrate as summary trials, he can because where the punishment he can invoke till up to 3 years, he can give them community services to the accused person. That is section 4F. Yeah. I was just referring to you. The witness protection scheme has been granted under the new scheme of the CRPC. That is section 398. Please note it down. 398 says that is a new section. Every state government shall prepare and notify a witness protection scheme for the state with a view to ensure protection of the witnesses. This was not there earlier. 398, which you may kindly take a note of. So then we traveling back to the Indian Penal Code, the new Bharatiya Nyaya Sahitya IPC, where section 43 abetment outside India has been added. Then we discussed section 69 newly added, sexual intercourse by employing deceitful means. We discussed it last time. I won't repeat it. Now today's topic which I am taking are from the IPC, the section which are again newly added. Section 95 is a new section. 95 के अंदर hiring, employing or engaging a child to commit the offences is a new section. This has been added for the purpose of using the child for sexual offences, exploitation is a new section. Section 96, procreation of a child, which was earlier 366A IPC के अंदर they used to use the word 366 के अंदर procreation was to a minor girl, which has now been substituted in the new Act, Section 96, which deals with even a child, irrespective of it is not just a, it is not a minor women child. The woman of 16 years old, it is irrespective of anybody can be prosecuted. The protection accorded under 96 to the children is wider than the one accorded under section 366A of the Indian Penal Code. That is, the kidnapping takes place if you kidnap a minor below the age of 18 years old with an offense. Now here, under the provisions of 96, if you kidnap any child, whether male or female child, or even a transgender child below the age, it is offense now under the provisions of section 96. New section. Then section 103 subclause 2, mob lynching is a new section under the IPC. New IPC, that is a Bharatiya Nyaya BNS. When a group of 5 or more persons acting in concert commits a crime, murder, on the ground of race, caste, religion, birthplace, now punishment is a death punishment, imprisonment of life. So you cannot be lynching anybody, killing anybody on the ground of race and religion or belonging to each area. It is a very serious section, 103. This is to discourage people fighting among themselves on religious grounds. There is a new section under 1062, that is death by negligence. The earlier section, what is 304A in the IPC, all of you know that. Here, offences escaping from the scene of offence without reporting to the police officer. Now, maximum term of 10 years time is given. Hit and run cases. अगर आदमी एक्सीडेंट किया रोड के ऊपर विदाउट इन्फॉर्म नहीं किया पुलिस को, भाग गया, it was earlier 2 years punishment, now it is 10 years punishment. Hit and run cases. If you inform the police, then it is 5 years cases, 5 years punishment. आदमी मर भी जाएगा तो, isn't it? Section 109 के हिसाब से. Then a medical practitioner who commit where on account of his negligent act, somebody is dead, the victim is dead, then in that event, punishment is given to him for 2 years only, like under the old 304A of the IPC. समझे ना, यहाँ पे ये changes किए हैं. Then another notable changes in the IPC are organized crime, that is section 111, providing for it's a new section, new chapter, kidnapping, robbery, vehicle grabbing, cyber crime, trafficking of a person, illicit offense. It is made punishable. It is a very serious offense. Oh yeah, yeah. Section 111. It is a life imprisonment punishment. Death imprisonment is given here. It's a very shall not be, and various, they are called out the various section, how much fine to be given. Fine is running from 5 lakhs. See, minimum 5 lakh rupees fine. to the person who is involved in organized crime of kidnapping, robbery, theft. These are the cyber crimes also. If death takes place, it will be awarded death punishment. If robbery takes place, minimum 10 years. It is a very serious punishment, and punishment as well as a penalty of 5 lakh, 2 lakh is very specific. 117(3) के अंदर where permanent disability take place of a person on account of this act, then the remainder of your life imprisonment is given. That vegetative state, like that Parel hospital nurse who was assaulted by the ward boy, she was in the hospital for several years before she was given, the Supreme Court allowed her to be killed. Euthanasia, which was passive euthanasia, was allowed to be given. Such cases where the person attacks and puts them in a vegetative state, remainder of life, lifelong. Then 117(4) can, when a group of 5 or more person acting in concert, grievous hurt करेंगे, punishment is now extending to 7 years. Earlier 3 साल थी, अभी 7 years हो गया. Punishment is now scratch. 112 is a new punishment, penalty for organized crime, petty offenses. Small offenses like theft, snatching, cheating, unauthorized selling tickets, unauthorized betting, gambling, selling. ये सब चीजें where the magistrate can award the community services. This is a new section. Then another drastic provision has been added, Section 113, Terrorist Act. Though we have a Mokoka State Act behind, under the General Act now, even unlawful activities act भी central का, वो भी इसके बावजूद भी General Act is now contained 113 Terrorist Act. This is very more drastic. Wherever here this provides that any person likely to threaten the unity, integrity, and sovereignty of the country, where using bomb, dynamite, of course, these are very serious offenses. Death penalty takes place for death, then loss of damage, destruction, property. Serious offenses here, punishable for 20 years. If death take place, he will be awarded death penalty. Then punishment with death, imprisonment for life, and also for fine. Okay. Then Section 152 speaks of endangering sovereignty, unity of integrity of India. 124 ये निकाल दिया गया, isn't it? Sedition. Sedition की जगह अभी नया section डाल दिया. The Supreme Court said was not happy with sedition provision. Many journalists were being arrested. Now, indirectly, the Parliament has enacted Section 152, endangering sovereignty, unity, and integrity. And let's see what does the Supreme Court say on this. It is a old wine in new bottle. Then 226, attempt to commit suicide, compel, restrain, exercise lawful power, shall be punished with imprisonment for a term extend to 1 year, or with both, or with community service. If you tell the magistrate in the court of law, I am going to award you punishment for 2 years, वो बोलेगा, अभी accused बोलेगा, no, if you give punishment, I will commit suicide. If you pass orders against me, I will commit suicide. That is, such person can be tried for attempt to commit suicide. So here, lower punishment is given 1 year's time. Then 304 is a new section, snatching, theft, snatching, committing theft. Here also punishment with imprisonment for descriptive term, which may extend to 3 years' time, liable to fine. So these are the new sections in the IPC. Now, if you see the Indian Evidence Act, not substantial changes, but they have added some definitions. What is significantly brought is electronic evidence is brought in the section, in the definition. India, now in the definition, section 1, India is omitted. Now, this applies to full India, including Jammu and Kashmir. The provisions of Indian Evidence Act earlier do not were applicable to Army, Navy tribunals. Now they are applicable. That is good. The martial law. No. The court martial proceeding under the Army, Navy, as well as Air Force proceeding, they are applicable. Now, as regard the uh, trial, then of course, before the arbitrators, not applicable. Affidavits, as usual, not applicable. But under the provision of CPC Order 18 Rule 4, they may be applicable wherever specifically stated. Then the new definition which is drafted is section 21D में BNSA में new definition word has been added. New definition they include electronic and digital recording. इलेक्ट्रॉनिक डिजिटल रिकॉर्डिंग का डेफिनेशन नहीं था पहले में, अभी दिया गया है, वो देख ले आप. Then 5 illustrations in the old definition remain, and the new definition has been given. The 6th statutory illustration, number 6, is given to the electronic record, email, server logging document, computer, laptops, smartphone, messenger, website, which have been added to section 21E, 21D के अंदर. 21E के अंदर of the BSA, the new definition of evidence include statements given electronically को भी ऐड किया, be treated as evidence as well as oral evidence. Now 21E के अंदर includes electronic and digital recording. So some modifications are done which you have to want it. In subsection illustration E of section 3.2, they have omitted certain words in the matter. What is omitted is you will find in section 2B, 2.2 of the BSA Act. So these are the minor changes or modification, reiteration. Or section 6 के अंदर, that is motive preparation, that was earlier section 8, motive preparation conduct. Sections are changed now. दो सेक्शन कम हो चुके हैं अभी. They have now instead of advocate की जगह वकील बना दिए. So the object was they didn't want English name, they wanted Indian name. Now यहाँ पे advocate was the English name. Now they have brought it was wakil was the Indian name. It has been now replaced. Now they made it an advocate. So we had to ask the legislatures whether you want to substitute both. So they were saying it was a British. We did not want to remember the British names, so we wanted to have the Indian name. So they removed the expression wakil, which was appearing in section 8 earlier. Now they brought as an advocate. Okay, that is no problem. Now in section 21, where admission was the section 17 earlier, the expression barrister, pleader, attorney, wakil has been removed. Advocate rakhe hain abhi. These are the only minor changes in some of the provision. Now, section 26 mein, where confession can be recorded by the magistrate, does not include village officer. That has been omitted now. That is earlier section ke andar. Give me the old Evidence Act. What is the old Evidence Act here? Section 26, 27.
26.
26. Now, if you see old section 26, there was a reference to magistrate does not include the head of a village discharging magistrate. Now, that is section 26 में. Now यहाँ पे वो निकाल दिए हैं. That means for recording extrajudicial confession, even they can also take the services of the village officer. Now the expression judicial magistrate under 164 CRPC who can record confession is now removed to magistrates. That you remember the changes here. Now, wherever the word electronic evidence is, they brought electronic and digital, even in section 32, where relevancy of statement with regard to any law. Then section 52 के अंदर new facts which the court shall take judicial notice of. That was earlier section 56, 57, 58. Now 58 में they have now included they removed the word 52 Parliament of United Kingdom Local Act UK correctly so. There's no bar because this was the act which was passed during the British time. There is no point in keeping a United Kingdom act passed by the United Kingdom. It has been rightly removed. Then they also omitted the accession and sign of sovereign of the United Kingdom British. Wherever the British is appearing, they have deleted it, no quarrel about it. Okay. These are the minor changes. Then under the provisions of the admissibility of electronic evidence record, the sections are PSA के अंदर that is electronic digital evidence section, earlier section 61, no sorry 58, corresponding to section 63 of the Evidence Act, that is what is secondary evidence के अंदर they also incorporated now the expression oral admission, written admission, evidence of a person who has examined a document, original document consisting of numerous accounts or other document, examine unskilled examination document. Then 63 के अंदर computer and computer device has been added. Okay. These are the provisions, more or less, wherever these are the changes. That is, computer and communication device has been added wherever it was not there under the Act. That is, everywhere they added these changes in almost all sections. Please note that wherever private document, public document, and the expression reference to Jammu and Kashmir has been removed, because Jammu and Kashmir is a part of India now, and is now. Oh yeah. Then under section 60 of the BSA Act, which was section earlier 81, London Gazette has been deleted. Then Act of the Parliament is omitted. These are the changes. Then under section 81, presumption as to gazetted electronic and digital record, which was section 81A. Some changes now brought. Every electronic record is inserted. Electronic digital record is inserted. However, 81A does not clarify to what is the proper custody. Proper custody explained nahi kiya. That is one mag. Then 85A के अंदर electronic digital add किए गए. 85A के अंदर digital signature has come into picture. Then 88, presumption as to certified copies of foreign judicial record, which was earlier section 86. उसमें Her Majesty's dominion are removed, omitted. Okay. Her Majesty will go away now. Now it will be the foreign Indian ambassador, any foreign officer in the officer, certified copies obtained, he has to certify them. So those copies, you don't have to go to London, you don't have to go to the British Parliament. Rightly removed here. There was no question of going to Her Majesty's dominion. That is the correct change. Yeah. Then under the provisions of section 92, which was earlier section that is a document up to 30-year-old document. That is section 90 earlier. They have omitted a certain 90A के अंदर BSA refers to custody of the document. Minor changes. Then in the topic of estoppel, section 115, 116 के अंदर they have made some changes. Any time thereafter की जगह वो add किए हैं कुछ. Lunatic has been replaced as a person of unsound mind. Please note that IPC के अंदर भी CRPC and Evidence Act में there is no lunacy. Now Lunacy Act has been repealed by the legislature. Then Indian Mental Protection Act has come into picture. Now that lunatic has been replaced as a person of unsound mind. Unsound mind. Then again section 132, that is professional communication, privileged communication, which was earlier section 126. उसके अंदर barrister, attorney, pleader, वकील निकाल के advocate डाल दिए. They made it short. That is good, not bad. Then wherever they got barrister, attorney, pleader, vakil has been replaced now advocate. That is privileged communication between the client and advocate cannot be revealed. That was the 126. So wherever the expression appearing legal, professional, advisor, barrister वो निकाल दिया गया. So they try to cleanse the system. यहाँ पे but what is not mentioned is then what is importantly that under the Evidence Act, all of you know that evidence which is illegally collected, it may be, if it is relevant, can be admissible. They are not explained this. Illegally obtained evidence is relevant in England. In USA, it is not relevant. That is called fruits of poisonous tree. The evidence which is illegally taken without the consent, like you have tape record कर दिया आप, किसी की recording कर दिया आपने without the consent. Of course, Puttaswamy says is a privileged communication. But Evidence Act में there are no changes brought about. Now in Rafale's judgment, you know that Supreme Court said that yes, N. Ram, the editor of the newspaper, said that I have parliamentary proceedings के record मेरे पास हैं to show that the Parliament, Indian legislature had paid X amount for obtaining Rafale deal at the time of the signing of the deal, but the amount was enhanced 3-4 times more. I got the papers and Ram collected the papers. Government of India tooth and nail opposed it. These are privileged documents, secret document, and illegally obtained document not relevant. But the Supreme Court said it is relevant. Of course, relevant, but the Supreme Court did not give any finding on the ultimate whether the disclosure should be done or not. But the public interest litigation which was filed by certain NGOs were dismissed. But the fact that the Supreme Court accepted the fact that the evidence relating to Rafale deal is illegally obtained is admissible. That judgment of the Supreme Court you also can see under the judgment of Supreme Court in 1973, R.M. Malkani versus State of Maharashtra, where the evidence, where the tape record evidence of what is the gentleman called Mr. R.M. Malkani, who was a coroner of Bombay, who demanded bribe from the doctor for suppressing the, which was recorded by the police upon the complaint filed by the doctor. The Malkani took up the objection. No, it is illegally obtained evidence without my consent, not admissible. Of course, under the provisions of Article 20, subclause 3, you cannot be compelled to be a witness. वो अलग बात है, isn't it? But a person cannot say under the Evidence Act, I will not give evidence. Now, under the scheme of the provisions of Section 133, Volt 33, new section निकालो था. Section 133. I will give the right section.
138.
एक मिनट. The right section and the old section and new section will give you. 132. Witness is not excused from answering on the ground of answering will criminate. This is directly in contrast to Article 20 subclause 3. Now, under the present BNSS, the new section is 137, which says that witness not to excuse from answering on the ground that the answer will criminate. Isn't it? There is no changes made here. So the legislature has not explained whether the illegally obtained evidence, fruits of the poisonous tree, can be received in evidence or not. Explain karna tha ye amendment mein. So once again, the legislature has missed the opportunity. Okay, it's very unfortunate. Now the final touches in the final touches would like to give is the Act has been further condensed. 167 में provision tha earlier. Now jury has been removed now. The earlier section was the earlier section relating to jury was of course jury system is abolished. 166 is now deleted. Power of the jury to or assessor to put question. Under the Evidence Act, the learned judges under section 165 can put questions to the person or order any document, whether relevant or irrelevant. But you as a witness, parties can only ask questions which are relevant. They cannot ask irrelevant questions. Court is given wide power. Now earlier jury was given power. Now the jury system is abolished after the Nanavati trial case. So 166 will go automatically. The new provision in the BNSS is section 168, power of the judge to put question on production. Okay. These are the changes which are brought about in the three acts which we have now substantially covered. Anybody wants to ask me any question, please ask. I will wind up. So these are this is the last lecture today on the new laws, both CPC, CRPC, Evidence Act, and IPC, Bharatiya Nagrik Suraksha Saitya, and Bharatiya and the Bharatiya Nyaya Saitya 2023 and Evidence Act Bharatiya Sakshya Adhinayam 2023. So it will, I will have to get used to pronouncing in Hindi dictation. It will happen soon. So anybody want to ask me any question, please ask कीजिए. ये lecture के बाद हम ये chapter बंद कर देंगे. Maybe after 1 week or 2 week, 3 week, I propose to take lectures on specific relief act and trial in civil cases, along with the relevant provisions of CPC and Evidence Act. बाद में लेंगे अभी आराम से, because courts are open now. You will be busy and I will be busy too. But every week we'll try to keep a lecture on the specific relief act, which is a very important section, and civil trials, with reference to the Code of Civil Procedure and also Evidence Act. So we will brush up our new Evidence Act, that is Bharatiya Sakshya Adhinayam, when we take up civil trials. वो होने के बाद it may be 3 months, 4 months, 6 months criminal trial के ऊपर एक रखेंगे lecture. Okay, with this I would like to wind up and say thank you to all of you, and my thanks to Ashutosh and Parimal Wag and all my juniors and assistants, especially today Sayali has been there, and earlier many other juniors, right from Kevin, Sama, Emma, Minal, and many other. If I don't take their names, they should not feel bad. They have been cooperated and given me full help in recording their evidence, because I'm not familiar with the computer system. So all my juniors and all the young lawyers have assisted me, including Ashutosh, and of course, if I don't mention Mansi, who has been helpful to me all the time, and many others, many of my students. Thank you so much. Anybody want to ask any question? Finally, thank you to you all. कोई सवाल है किसी के? Nobody is there. Okay, Ashutosh, shall we wind up?
Yes, sir, we can.
Ashutosh is there.
Yes, sir. Am I audible, sir?
He's not audible.
Not audible. पूछो देखो ना. कौन है? कोई है? Ashutosh is there.
Yes, he's there. He is speaking, but he's not audible. Yes, he's here.
You're not audible, Ashutosh.
He's here. Okay.
Okay, thank you everybody. Good night. I think many of them are. चले गए लगता है बहुत सारे लोग.